So if you're a landlord in New York and you want to know the proper way to evict a person, here's a video that I think that you need to watch before you get started. Hey guys, Rummy here with eXp Realty, your real estate experts, your local realtor. I put the real in real estate. So let's get into it. And I'm going to make sure that you guys understand how to properly serve your tenant when you're evicting them out. And again, it has to do with the lease and how you properly serve them, because even one wrong step could make you redo the process, lose rent. Number one, you have to follow the HSTPA, which is the Housing Stability and Tenant Protection Plan Act, which states that if you want to evict someone and you want to terminate any tenancy, here's what it says and how much notification that you need to have. Number one, the time frame that is required. If the tenant is residing in the unit for more than 2 years and has a lease for more than 2 years and more, you got to give them 90-day notice. A 90-day notice, not 30-day notice, not 60 days, 90-day notice. If the tenant has lived in the unit for more than 1 year, but less than 2 years, or has a lease term of more than 1 year, but less than 2 years, is 60-day notice. Okay, I hope you got that. Again, making sure that you get the right format. If the tenant has lived in the unit for less than 1 year and has a lease of less than 1 year, then it's a 30-day notice. Now, there also is a 10-day notice too as well. The 10-day notice state if there's any illegal activities that is happening, you have the right to give them a 10-day notice. Now, let's get into how the notice needs to be served. Number one, personal delivery to the tenant. Number two, delivered to a person of suitable age and who's at the premise, followed by a mailing which is certified. I recommend that. If the first two steps are unsuccessful, then what you want to do is leave a notice and stick it to the door and mail a copy as well. Okay, it's important that certified mail alone is not insignificant. So improper service will render the notice legal defect. Okay, what happens if the notice is not served, is wrongly served, right? If the notice is wrongly served, again, I'm just reading off the law right now, result in a discipline of your case in high court, requires you to start the entire process and delaying possession, cause lost rent and income and potential attorney's fees for the tenant, not for you, for the tenant. In some cases, exposes landlord for allegations and harassments for improper eviction. So again, properly making sure, listen to this video, because I had many clients that didn't do these steps and they had to restart this over. It took them 6 months, 12 months. And I have clients that has nightmares for 2 years. So again, in New York City, in New York, how to properly go ahead and serve the tenant as you move forward. Serving the correct notice at the correct time in the correct manner is a fundamental to anybody's success in eviction for renewal action. It often is the first document that the court will look at, because if you don't have these documents, you don't have this categorized properly, and any single error can undermine the entire process. So again, you could get an attorney, but if you don't do this right and properly, or if your attorney doesn't do this correctly, then guess what? You have to do the whole process again. Guys, I do have attorneys that are out there that are specializing in this. Reach out to us, consult with us to help you, making sure you pick the right person. And again, read that law again. The law is the HSTPA, which stands for the Housing Stability and Tenant Protection Act of 2019. Have an amazing day, guys. Your real estate experts giving you the real and real estate. Have an amazing day.